All right, good afternoon, everybody. I'm Iain McMenamin. I am the chair of this second panel this afternoon. It's welcome back for most of you, and it's welcome for the first time for some of you, like myself. So I'm the head of the School of Law and Government, and one of the many pleasures of my job here is to occasionally chair very glamorous and fascinating panels that Federico has put together for us. So today, this panel is about economic relations, following on from the earlier panel. And we've got three papers or three talks. The first one is in trade in goods, and it's by Giorgio Sacerdoti and Paola Mariani from Bocconi University in Milan. The second one is on trade in services, and that's by Niamh Moloney from the London School of Economics. And then finally, we have Catherine Barnard and Emilija Leinarte from the University of Cambridge on the mobility of persons. So each paper is going to be 15 minutes. We're going to keep strictly to time because these are clever people who can express their ideas succinctly, and because you're going to have lots of questions and comments to put in later. So we're going to begin with the first paper on trade in goods. I'll just tell you a little bit more about the two presenters. So Giorgio Sacerdoti is a professor of international law at Bocconi University in Milan. He's also a Jean Monnet Chair in European Law, and he's been a past member of the WTO appellate body and an investment arbitrator. And he's presenting with his colleague, Paola Mariani, who's an associate professor of law at Bocconi, specializing in private international law and EU law. So I think Paola is going to speak first, and we're very much looking forward to what you have to say, Paola.
Thank you, Iain, for the floor, and thank you, Federico, for having involved Giorgio and me in this challenging project to be between the first ones to comment this incredibly complex treaty. And I will use my time just to mention 5 peculiarities of the trade in goods chapter of the TCA before giving the floor to Giorgio to continue in the presentation. Well, the first peculiarity of this treaty, and in particular the trade in goods chapter, is that trade in goods is the core of the free trade agreement. And why is that? Because the provision on services and in investment are almost inexistent. It's so because you know, the position of the UK was especially to regain freedom to regulate, and the effect is that we have a trade agreement, an old trade agreement. We can say a trade agreement of the old days when trade was intended more for goods than for services. And in this, and so you see, this is quite unusual because the new generation of the EU trade deal focuses much more on trade and on services and investment than what the TCA does. The second point is that this treaty, despite its resemblances to other preferential agreement, EU preferential agreement, it's a speciality. It's something completely new in the EU trade relation with third country. In fact, TCA triggered a reverse process intended to terminate open and liberal trade relations rather than create them. And the provisions are intended to regulate obstacles rather than removing them. This is the effect of the decision of the UK during the negotiation to prioritize sovereignty over market access. We cannot forget that the standing point of economic relation between UK and the other 27 members of the EU at the time of entry of force of the treaty last 1st January was the single market and the custom union. It means the deepest form of economic integration, the deepest form of economic integration between states, and this is the first time that the free trade agreement that usually is meant to further trade relation, trade liberalization between the parties is being used to the contrary, to operate a less open regime. On this point, it's quite interesting to note that how much of the GATT vocabulary has been used in this treaty. This is again back to the past. Another peculiarity of the new EU-UK trade system is that is Northern Ireland, because you know, Northern Ireland is under a different trade on goods regime. This regime is regulated outside the TCA in the withdrawal agreement, and especially in the protocol on Ireland and Northern Ireland. You know that the compromise reached by the UK and the EU on the withdrawal agreement was to keep Northern Ireland in the EU's market for goods, even if it's part of the UK single custom territory. This is a very new situation, unusual situation, and leaving aside the problem and the concerns over the implementation of such a complex regime, because we know that from the news that, and now from the position taken by the Parliament, that it's really difficult to implement this incredibly complex regime. From a pure legal perspective, many questions arises on how these two regimes will interact and influence each other. Sufficient to mention that while the TCA in principle does not produce a direct effect, the withdrawal agreement, as Dagmar pointed out in the previous session, and of course, Northern Ireland Protocol is binding as the withdrawal agreement, is capable of direct effect. And so you can imagine from a EU point of view and all the complexity of this legal settlement. Fourth point, the TCA left many details of the new relationship, trading relationship between EU and UK to be determined by the Partnership Council or by many joint committees and working groups set up by the treaty. To that extent, in the treaty, and especially in the trade of goods chapter,
1 minute, please, Paola.
1 minute, okay. There are many provisions covering commitments to continue negotiation. The TCA is a working process. It's a start of a process, so it's quite difficult now to give a precise description of this process. And finally, my final point is that the TCA, of course, is a treaty and is better of a no-deal scenario. Why? Because in the TCA, sorry, establish the continuation of tariff and quota-free trade between the parties. However, this achievement needs to be set against many other sources of trade cost. the TCA inaugurated heavy border controls, the respect of standard, origin of products, health checks, as operators have discovered at their cost immediately after the entry into force of the treaty. These controls are necessitated by the absence of commitments by the UK to stick to the EU regulation in this matter. In order to avoid...
Paola, sorry, if you want to split...
Yeah, but I'm just finishing. In order to avoid that the recovered freedom to regulate by the UK leads to imbalance to the market, and a new system has been introduced, the level playing field. And I give... Okay, I'll give the floor to Giorgio because he will relate on this. Thank you.
Giorgio, you can take away the second half now, please.
Okay, so without much ado, I will go on. I have to assume that all have a certain knowledge of this agreement. In studying and trying to and making my part of the paper on the level playing field, what strikes, we must say, is it's clear that it was also written hastily, and it's really difficult on certain aspects to be sure that one's comment is exactly what was meant. Maybe that it was not meant, the two parties didn't have the same ideas, and that's why it has been hastily made in pieces. So I would say this level playing field sector is an absolute novelty, I would say. You don't find it usually in free trade agreements. You may have some guarantees of countermeasures in cases of breach following the GATT of the WTO, but not such an elaborate part. And I would distinguish the substantive part and the procedure. The substantive is that the parties look and strive to have a level playing field for open and fair competition and sustainable development. And this is based on the recognition that so much trade is going on between the two parties. So on one hand, the TCA reflects the divorce. On the other hand, and that I think it's a good figure, the withdrawal agreement was a divorce. And this is a post-divorce agreement. We have children in common. Trade is the first children, the trade in goods. And we have to deal with that and administer it in a way that it will not be hampered and suffer too much. But each has its own post-matrimonial relations, and each wants to be independent. And therefore, it's difficult to make connect the level playing field. First of all, there is a commitment to keep high levels of standards in competition, in labor, and in environment. That's very important. That is excluding the Singapore type of competition of the UK just outside the channels against the EU. And it's quite interesting, their commitment in all these areas to existing treaties, existing labor, international labor standard, the Paris agreement, the Rio agreement, and so on. At the same time, I think there is a mistrust that this might not be respected by the parties. And why so? Because it's clear, and it's written in various points, that there is a freedom of regulation, the right to regulate. There is no harmonization. Each party, and of course the UK insisted very much, is free to organize itself in order to maintain these commitments. And therefore, whether these commitments will really be maintained can be open to doubt. And therefore here you come and we see already something. Maybe the UK will change the labor law. Maybe some pesticides which are not admitted in the Union will be admitted in the UK. So how to react, even if both parties commit, and that's especially for the UK, to have anti-competition authority, to enforce the labor standard, to enforce the environment standard seriously. And here comes this mechanism of dispute settlement, and what has become focused in the one of rebalancing. So in the section of chapter, I don't know how to call them, on competition, on labor and environment, the mechanisms are similar, but not identical. That's make it very complicated. And the mechanisms are not the one for the disputes under the DCA in general, which are mostly explicitly excluded from application in this chapter, in these sections, but some specific mechanism. Now, I would say the one in subsidy, it's the first that comes in the list. It's very specific. When do you start this mechanism? Well, in subsidy, it's when one party considers that the subsidy, through subsidy, there is a serious risk that the subsidy will cause a significant negative effect on trade or investment between the parties. This is quite, the standard is rather high, I would say, so I understand it. And probably, and I saw the Financial Times say, well, it will be inapplicable, because how can you show really that the subsidy has this specific effect? Well, it can be, because subsidies are usually enterprise specific. So if there is a subsidy to a steel enterprise in Belgium or in the UK, it may imbalance a competition against the competitors on the other side of the channel. Whereas in the labor and environment standard, the standard to take it, I think it's lower, because these are global regulations. If you admit higher number of working hours per week, then you may have an effect. Or if you admit emissions which are higher and cars that have a lower standard, then this can affect you. So first you have in this mechanism, I have just a few minutes, conciliation, but at the end, if the party affected thinks that not necessarily it's a breach, but this is very important. In subsidy, it must be rather a breach of the provision. Here is just a negative effect. It reminds the no breach provisions of the old GATT. Then the other party can...
Giorgio, you're over time. If you could just conclude quickly.
Yeah, can make rebalancing provisions. And these are subject, and which can even be introduction of custom duties. This is very dangerous, I would say, in the general economy. And the other party can trigger very speedy arbitration. The measures are suspended in part during the arbitration, like 30 days. And the arbitration is, however, more on whether the rebalancing provision are fair than whether the original measures are correct or are not in breach. And this I find a little bit strange. And this is the mechanism. How much will it be resorted to? It can be very contentious, or it can be dissuasive, that this party will remain and stick to the obligation to maintain the level playing field by fear that this mechanism will be effective against them. That's my introduction, and I look forward to hearing the comments of the other experts, because really it's very difficult to navigate these provisions. Thank you.
Thank you very much, Professors Mariani and Sacerdoti. So our next presentation is on trade and services, and it's by Niamh Moloney, who is the head of the Department of Law at the London School of Economics. Her book on EU securities and financial market regulations is now in its third edition, and she has a number of other monographs as well, which will, I'm sure, make the third and subsequent editions too. Amongst other roles, she's currently a member of the board of the Central Bank of Ireland and sits in many other regulatory bodies and committees. Thank you very much, Niamh. Off you go.
Thanks very much, Iain, and warm thanks to Federico and the DCU Brexit Institute for this incredibly rich and really timely event. It's great to be here. And I'd start off by saying, very much like Paola, I'm dealing with a story of sovereignty versus market access and sovereignty trumping. But I suppose, unlike my other colleagues, I'm telling you a story of no deal. And showing you how that relates to the Trade and Cooperation Agreement. So I'm looking at services and specifically financial services. So there is no deal for financial services. There's absolutely no surprise. This has been well signaled since around about the middle of 2017. But nonetheless, I think it's important to play out the issues here. And also, we immediately see the visceral reality of the TCA. Because a couple of days ago, it was announced that Amsterdam had become the leading centre for share trading in Europe, away from the City of London. There is absolutely no economic rationale to this whatsoever. In trading markets, liquidity follows liquidity. There is no reason why liquidity would move from the London Stock Exchange to Amsterdam. Why? It's a legal consequence. And it's a legal consequence of the Trade and Cooperation Agreement, because the UK is no longer equivalent, and thereby consequences follow. So just to reiterate, this is real, it's legal, but it has absolutely real impact. So what does it mean that it's a no deal arrangement? Well, prior to Brexit, the UK benefited from what was called the Financial Services Passport. It is the towering achievement of financial services law and policy in the EU. Although financial regulation or financial markets are about the most heavily regulated part of the modern economy, with huge transaction costs, there is a passport in the EU system whereby actors can move freely around the single market because they're all operating under the same rule book. There's nothing like this internationally. It is a huge achievement. On Brexit, the UK lost access, obviously, to that because it's part of the single market. And it brings us into the Trade and Cooperation Agreement. Now, the Trade and Cooperation Agreement is like every other trade agreement that the EU has negotiated in the area when it comes to financial services, in that it leaves access to the EU a function of three modes of access. So one is repatriation of business to the EU. You become an EU firm, you become a subsidiary, you thereby benefit from the passport. Secondly, you negotiate individually with 27 states. So you're landlocked. Now, when it comes to financial services, that's hopeless. Financial services operate in a frictionless cross-border manner. So that's impossible, but in effect, just simply not practical. And that leaves you with the third option, which is the equivalence regime. And the equivalence regime is not in the TCA. It is a legislative system under which the EU, if it thinks that the third country's rules, i.e. the UK, are broadly aligned to, in practice, really very close to what the EU rulebook looks like, you can then access the EU off the back of your home country rules. So in financial services, the game is transaction costs. It's how high is the regulatory burden when you access the third state, and this is all about sort of the equivalence system. So how does that come out of the TCA? Why am I saying it's a no deal? Well, financial services operates under the general services provisions, and the services provisions tell us that there is a right to market access, set up a subsidiary, there is a right not to be discriminated against, but notably there's a carve out for financial services, no most favoured nation treatment. There's no MFN for financial services. So the EU can, if it wants, build kind of super whizzy agreements with other third countries, and the UK won't have access to them. Right, so we have services, we can set up a subsidiary or a branch. That only gets you about 1/10 of the way in financial services, because the costs are all about the regulatory transaction costs. So then you move to the financial services space, hoping for an answer, and no, there is not one, because it is very thin, it's very meager. The financial services chapter is all about nice statements about let's protect the confidentiality of information, let's be nice to one another, let's cooperate. But it doesn't get at all into the granularity of regulatory costs, simply not covered. Again, not unusual. That's how the EU manages financial services when it comes to international trade agreements. And above all, there is the overarching WTO provision, which is, of course, very much part of the TCA, the prudential carve-out. Nothing in the TCA prevents either party from adopting or maintaining measures for prudential reasons. What are prudential reasons? It's the gamut. Investor protection, deposit protection, market efficiency, it's essentially a right to regulate. So where does that leave us then? It's all about the equivalence system. Now, what do we mean by equivalence as a matter of law? It's a legislative arrangement. It's not in the TCA. It's been around for, 30, 40 years. It's only recently become extremely high salient. It was never meant to carry the weight of the UK as a third country, but it's become very, very high salience now. But so as I said, if a third country is equivalent, then you get access to the EU on the basis of your own country's rules, hugely valuable for a financial services firm, decided by the Commission. It is a very intrusive process. It involves a really deep dive into rules, supervision and enforcement. It is unilateral, it is discretionary, and it is contingent. It can be withdrawn by the EU at any point. It has an incredibly strong gravitational pull. To be equivalent, your rules have to pretty much stay dynamically aligned with those of the EU. So into the future, regulatory autonomy is effectively lost because you're pulled into the EU's regulatory orbit if you want to stay equivalent. Now, where we are right now is there are no equivalence decisions. There were not in the TCA. There was no preferential treatment. There is a commitment in the TCA to put in place a memorandum of understanding by the 31st of March to establish a framework for structured cooperation and talking about equivalence. But that's pretty standard in how the EU interacts with everybody. There's generally some form of MOU when it comes to sort of sorting out financial services relationships. So there's no particular magic to that. And at the moment, there's no great optimism for what this is going to produce in terms of equivalence. So what are the implications? Pulling it together, yes, you can repatriate. So under the TCA, you have the right to set up a branch, to set up a subsidiary and to provide services. But subject to the right to regulate, and that's, as I said, where the costs are, or you're into the equivalence regime, to kind of avoid the regulatory costs. Now, on the two models, repatriation, yes, that's happening. So very much since 2016, Dublin, Frankfurt, Amsterdam, Luxembourg, they have been the big winners in the post sort of Brexit carve out of financial services. Legally speaking, it is not cost free. So becoming an EU firm requires full engagement and embedding in the EU legal system. A subsidiary cannot be used as a sort of a backdoor pipeline to effectively operate from the UK. The European Central Bank, the European financial authorities have all made quite clear, if you're becoming an EU firm, you're becoming an EU firm with serious transfers of asset risk management and all the rest of it. So then if you don't want to do that, and obviously there's very strong reasons, certainly from a UK perspective, why you wouldn't want business repatriating to the EU, we're back into the equivalence system. A brief footnote here on why it matters that the UK has not formally been declared equivalent. Just going back to the Amsterdam example, why did that happen? Under EU capital market law, shares in the EU must trade on an EU trading venue or on a venue that's equivalent. So January, the London Stock Exchange is no longer an EU trading venue, but neither is it an equivalent venue because the administrative technical process had not happened. Were the rules equivalent? Yes, of course they were. But this is a process that has to happen. It is legally and administratively necessary for those declarations to be made. Hence, all the trading moves, really defeating all sort of economic logic. But once you set up those liquidity patterns, there is the risk that business sort of keeps moving. So just sort of in my last 5 minutes then, if that's where we are with the repatriation model or the equivalence model yet to be granted, what conclusions might we draw from how the TCA has sort of dealt with this issue? I think very much on Paola's comment, it is a collision between two competing concepts of sovereignty and how that then got played out in a really competitive area. I mean, this is the thing, this is still a fairly nascent, still a fairly dynamic area. The UK is hugely dominant in financial services. The EU is building its financial services capacity. So that layers into the competing concepts of sovereignty and makes it even more complex. So the EU is cleaving to its standard position. We retain control of our rule book. We retain control of our financial markets. If you want to play in our field, you're going to have to follow our rules or become an EU firm. I think I should note here, this is not just about competition. I think it's important to remember here, when you're looking at competing regulatory views, there's a very long shadow of the financial crisis here. Yes, it's about competition, but it's also about an ideological and political folk memory of just how bad it was back in 2008, 2009, 2011, and the regulation that resulted from that. So really strong conception of sovereignty, that the EU must keep control of financial stability and must keep control of its own rule book. Pushing against that, you have the UK, one of the world's major financial centres, wanting equally to keep control of its rule book and not wanting to be a rule taker. Now, the UK, the Governor of the Bank of England, only very recently has maintained we cannot be a rule taker. As one of the world's largest financial centres, we must have autonomy over our rule book. And it's not that we're going to create a bonfire of regulation. No one is expecting that or wants that to happen. It's this dynamic alignment problem. Going into the future, we reserve the right to be able to adjust and finesse our regulatory system, as you'd expect from one of the world's greatest financial centres. And the two positions are right now absolute polar opposites. And for now, the sovereignty issues are, if you like, trumping on both sides, I might suggest, sort of the economic issues, because the more open that pipeline is, arguably, the better it is for both sides. Very little signs of an early accommodation here. While it's a matter of law, there are very strong economic incentives for the EU to sort of sit it out, because you increase the chances of repatriation. If we look at the political economy, going back over the last 2 or 3 years, we've had a few post-2016 legislative measures, refining and very much toughening the equivalence system. So certainly ECOFIN and the Council, while not directly obviously tackling Brexit as it were, but whenever they look at equivalence, and when they have done in the last number of years, they've been tightening the system. Summer 2019, we saw the first ever withdrawal of equivalence decisions that had never happened before. Now, it was in a very technical area, it was not unexpected, but it got this very, very strong symbolic effect that the EU, yes, they can withdraw equivalence at any time. And I think a final example, if you forgive quite a legal one just for my closing minute or two, to show you where the balance of interests lie. So there's a part of financial market infrastructure called a central clearing counterparty, or a CCP. Now what a CCP does is it's sort of like a nuclear power station. It gathers together all the risks in derivatives markets, which are one of the riskier parts of the financial markets, and it sort of stabilizes them, to put it really briefly. Now, most of the CCP activity in Europe, hugely important for financial stability, actually happens in London. So the EU did adopt a temporary equivalence decision, so the EU could benefit from the stability and power, if you like, coming out of London that was needed for the EU. Okay, so that's one major important type of infrastructure. There's another equally important kind of infrastructure, which is a stock exchange, but it doesn't have that same level of stability risk. The EU did not adopt a temporary equivalence decision for stock exchanges, and we saw the trading move from London to Amsterdam. So you see how the different kind of interests are likely to play out here. Very final comments. Looking into the future a little bit, we're beginning to see the EU focus very, very closely on building substitutes to the EU capital market, and that playing into law. So, for example, last summer we had the COVID recovery package, and it was unusually deregulatory when it came to financial services. So a little kind of sign how the TCA is now beginning to feed back into, to a certain extent, how the EU thinks about regulation. And equally, we see regulatory responses in the UK. So the equivalence debate, my own prediction would be the heat and light will go out of this at some point, and we will get a greater degree of accommodation, particularly once the technocratic part of this gets going, you know, when it's the agencies talking to one another. But we saw yesterday the Jonathan Hill review. It's a major review of how essentially stock exchanges and corporate finance is regulated in the UK, and it's a very clear statement of intent about how the UK plans to use its regulatory system to compete globally. So we see how the no deal is beginning to have sort of legal effects in both separate rule books, even as they still try and come to some accommodation as to how they're going to manage market access. Thank you.
Thank you very much, Niamh. So our final paper then is on the mobility of persons, and it's by Catherine Barnard and Emilija Leinarte. So Catherine Barnard is from Trinity College, Cambridge. She's a professor of EU and labour law at the University of Cambridge. She actually beats Niamh. She has a monograph that's in its 6th edition. And then her co-author is also at Trinity College, Cambridge. Dr. Emilija Leinarte is a British Academy postdoctoral fellow in international law, and has her first monograph, I think, coming out this year. So I think Catherine is going to begin and then pass on to Emilija. Whenever you're ready, Catherine.
Okay, thank you very much. Can you see the slides?
Yeah.
Thank you. Well, thank you first of all to Federico for organising this wonderful and extremely timely event. Emilija and I have been given the really troublesome and difficult topic of immigration. And I think I'd say up front, we don't really understand it. It is so complicated that everything we're about to say comes with the caveat, we might just be wrong. The only thing is everyone else I talk to also says the caveat that they might be wrong. So we're all wrong together. So I would be grateful if anyone spots the many mistakes that no doubt there are here, because we are learning. And it must be said, this is one of the most difficult parts of the treaty. So in brief, we know that immigration was one of the main reasons why people voted Brexit. The scatter chart, which was produced the day after the referendum, shows that loud and clear. The larger the font, the more relevant the issue was to motivate people to vote for Brexit. And it's abundantly clear that it was immigration front and centre. And what does that mean? Well, it means turning off the rules that we have learnt and benefited from for years, namely rules on free movement of workers, freedom of establishment, and free movement of services, the rules that Niamh has been so beautifully referring to. What have we got in its place? What we've got in its place is a three-pronged regime which combines continuity with the settled status scheme, extraordinary complexity, and that's what's in the TCA, and a brutal rupture with the past, and that is for anyone who arrives in the EU, in the UK, from the EU, from the rest of the world, after the 1st of January.
Catherine, sorry, can I step in just to suggest that you click on the slideshow below your, if you may, so that it becomes, your screen should open up and we see it more clearly.
I thought I am on the, it's on my screen, it covers the full screen. Is that better?
Yes, perfect, thanks.
Okay, perfect, all right, thanks for telling me. So to start on the left, this is continuity. Continuity is the EU settled status scheme. Anyone who arrived in the UK before the 1st of January, or conversely in an EU member state from the UK, can apply for EU settled status or the equivalent. And that essentially gives them the rights that they had as an EU citizen. It is an extraordinary process. It should be as simple as having a cup of tea. It should take you the time it takes to make a cup of tea, hence the government publicity. And that is the case if you are clever, literate, multilingual, and you have a snazzy phone. If you work in the fields, you scarcely speak any English, and there's no Wi-Fi, it is infinitely more difficult to apply to the UK government for EU settled status. For those EU nationals arriving after the 1st of January who want to work on a permanent basis, clearly Article 45 has been turned off, and they are subject to national immigration law, which means visas. The UK has the most expensive visa regime in the world, and it will be very difficult for low-skilled workers to come to the UK. And then that brings us to the delights of the TCA. The TCA is brutally complicated. It's so brutally complicated that we're not sure we've got it right, but we have tried very hard. And it builds on the 4 modes that Giorgio knows and loves from the delights of GATS. We have concentrated primarily on mode 4, which is the one that people are most interested in, which is about the mobility of people. And the mobility of people is essentially nothing at all like what you find in Article 56. It's completely different, but in essence, you can move as a business visitor for establishment purposes, as a contract service provider, as an independent professional person. All of that is largely familiar to other free trade agreements, and then also the delights of short-term business visitors. Now, given how complicated this is, I've left it to Emilija to explain the difficulties. Shall I take the next, shall I move on to the next slide for you, Emilija?
Yes, that would be great. Thank you very much, Catherine. So as Catherine has made it clear that the new mobility regime under the TCA cements sort of a fundamental change from a free movement provisions to sort of WTO style trade in services regime. So the four modes of supply is sort of really following closely the structure of GATS, and the mode 4 is the mode for mobility that is most relevant for the mobility of persons. So then we have a question of who under mode 4 can actually provide services and what type of services. So here we have a graph which shows the very limited scope of the TCA provisions. Without going much into detail about each of the categories of persons that are covered by the TCA, it is important to know that these are the list of these categories is closed. Only those service providers which fall under one of the categories will be covered by the TCA. Furthermore, the categories of persons, of suppliers, are conditional. So there are a number of conditions attached to each of the categories. So for example, business visitors for establishment purposes must be in senior position in their firms, and also they must receive no remuneration for their work. Additional conditions apply for each of the categories. So here we have another limitation for who can actually travel when providing services. Then we move on in our paper to discuss also the sectoral limitations. So these were the personal scope limitations of who can actually provide services, but there's also sectoral limitations, and these two are very significant. Now, very briefly, because that's actually where the extreme complexity and confusion is. Here there is a difference between GATS and the TCA, and the difference is significant. So under the GATS, services liberalization provisions, commitments fall into two basic categories. Those are general and specific commitments. And while all WTO member states are committed to the most favored nation treatment for all services covered by GATS, no such commitment is for the national treatment and market access commitments. States members of the WTO can bound themselves as much as they wish in terms of these two commitments. This is the so-called positive list approach, and that's why GATS is considered a rather limited instrument in international services trade. The TCA follows a different approach, a negative listing approach. Parties are committed for mode 4, market access and national treatment provisions, unless they indicate in their list of reservation specific exceptions. So these are provided in the annexes to the TCA. And actually, as Professor Moloney mentioned, a very important point is that there is no most favored nation treatment. So this is extremely important, which is another difference from GATS. So we have those country-specific reservations for the different categories of services, and also for the different modes. In addition to that, there are sectoral limitations, general sectoral limitations under the TCA. For example, short-term business visitors have their own permitted activities list, as well as contractual service suppliers and independent professionals. So only specific sectors are covered by the TCA. Finally, there are very general carve-outs from the TCA services title overall. So the very important one, in addition to air services or audiovisual services, is services provided in the governmental authority. That's obviously very important because EU migrants played an important role in the public services sector. So to sum up, there are personal scope limitations, who can travel to provide services, and also 3 layers of sectoral limitations: country-specific, general, and overall carve-outs from the TCA. So With Catherine, we also looked into the chilling effects of such a limited instrument for under the TCA for mobility. One of the sectors that is really affected and is voicing a very strong criticism of the TCA is the fashion and textile industry. We obviously do not know the exact implications, negative effects of the TCA's restrictive mobility provisions because we are coinciding with the global pandemic, but the fashion industry is already very strongly expressing their concern, and they've sent an open letter to the Prime Minister last month to express this. This is a 35 billion industry, which contributes 35 billion to the GDP, and it is more than fishing, music, and film and motor industries combined. So it is an important sector that was left out of the TCA. It employs 1 million people. This is a sector that is heavily based on free movement, on movement of persons. For example, for the textile industry, 70% of workforce in London's textile manufacturing are from the EU member states. So this is a graph that Catherine is now showing to you. It was made in 2017, I believe, already voicing the concern from the textile industry representatives, showing what would be the impact going from the sort of very soft Brexit to the very hard Brexit to the industry and to the different activities in the industry, retail, market, and design. Fashion industry and textile industry is not the only industry. We also have musicians, and musicians is a very organized group who have been voicing their concern also in a very consistent and very strong manner. Musicians are also left out from the TCA as fashion industry representatives. They are not covered by the sectoral activities that are covered by the TCA. So they do not fall under the TCA mobility rights. There has been a sort of disagreement between the EU and the UK as to who is at blame for leaving the musicians, performing musicians out of the TCA. The EU's draft FTA of March last year provided for a 90-day visa-free regime for performing artists. This was done by including in the agreement a joint declaration which would exclude performing artists. Here is the text of this, from excluding them from the remuneration requirement, which would have prevented member states from requiring a visa for short-term paid activity of musicians. We don't have this in the TCA. The final text, it doesn't include this, and what we have in the text itself is no commitment for a visa-free regime for 90 days for paid activity. So obviously this will complicate matters for the touring musicians as fashion industry representatives greatly. Catherine, would you like to make any concluding remark?
No, only that this is not free movement in any shape or form. And the reality of this will only start to dawn when people start traveling again. And when they start traveling again, they will discover that they will be subject to considerable visa and work permit requirement. And then they've got to do battle with the immigration ministries of all of the 27 member states. And if you will note, if you look on any of the websites of any government ministries, there's a total lack of transparency about what the TCA and what GATS say in respect of service provision. There's stuff on the websites about what you can do if you want to get residence in the host country, but almost nothing about services provisions. Major issues about enforcement, very practical issues about which office do I have to go to get my work permit, how much am I going to have to pay? And then what happens if I don't get it? What are the sanctions that can be imposed against me? And what happens if a country doesn't comply? Because it's, of course, very important to note that unlike EU law, there is no direct effect of any of this stuff. And so I am reliant on going to the UK government and getting the UK government to intervene on my behalf. As a poor jobbing academic who is no longer allowed to examine a PhD in a nice country like Italy, I'm not sure I'm going to get much traction and much change out the UK government, who is going to ensure that compliance with TCA rights is respected by the Italian government. Thank you very much indeed.
So thank you very much to Emilija and Catherine, to everybody, for those really clear and stimulating presentations. And of course, more importantly, from a chair's point of view, your good timekeeping. So that means we have over half an hour for questions. There's two ways to ask a question. One is to send me your question in the chat, and we have one of those already. And the other way is to raise your hand electronically, and then you'll be unmuted. So I have one question from Kevin Buckley, which I'll ask straight away. He says, in a rush to stop immigration into the UK and stop free movement, it seems to be lost on many in the UK that freedom goes two ways. How's that being masked by COVID-19? So I think that's probably mostly to Catherine and Emilija. Do you, maybe we'll gather together a few questions because there might be a lot of them. So if you can reflect on that one. I think Giorgio has a question. Go ahead, Giorgio.
Thank you. Yeah, my question was very interesting on MFN. You said there is no MFN and this where there is freedom of service. Do you mean MFN among the 27 viewed from the UK, because the freedom of services for extra EU service providers mostly left to national governments nowadays in the EU? Or you mean towards GATS members which are not part of the TCA?
So listen, people are probably so confused by the immigration rules that they can't get their heads around asking a question yet. So let's have responses to those two questions while everybody formulates their own questions. Maybe Catherine and or Emilija first.
Emilija will tackle the hard one about MFN because it's something we've been struggling with. The first question, I lost you. My line went dead. Iain, could you just remind what the first bit of the question was?
Sorry. Okay, I'll read it out again. It's from Kevin Buckley, and he says, in a rush to stop immigration into the UK and stop free movement, it seems to have been lost on many in the UK that freedom goes two ways. Has that been masked by COVID-19?
Yes, absolutely. And in fact, what is absolutely astonishing is that the recent figures show that London itself has lost about 800,000 people in the course of COVID, and it's not quite clear where they've gone.
Wow, that's astounding. And Emilija, do you want to take on Giorgio's question, please?
Yes, I don't know if I have I know I don't have a clear answer to this, primarily because the other EU new generation free trade agreements, such as CETA, also do not include the MFN clause. So it's very difficult to, the way that I understand it, the MFN clause in this situation would be applying to external relations. So not to the EU 27, but to the external, so to the other free trade agreements, to the other treaties. But it's very difficult to know what kind of MFN clause would be included, because we don't have such an example. We only have it in the GATS agreement. And that obviously applies not within the EU 27, but with the in the relationships with other WTO member states.
Okay, thanks. So we have two more questions. The first one's from Fiona Flood, which I'll read out, and it's again trying to make life even more complicated by multiplying COVID by Brexit. So she says, of course, thanks for the great presentations, and her question is, could the panel provide a view on how impactful the lack of freedom of movement implications of TCA will be post-COVID versus the goods impacts we've seen since January 1st? Also, she's responding to Catherine's invitation for a correction, and she says to take into account the common travel area in her complex chart. And then also we have a question from Gavin Barrett, who might unmute himself and just speak it out for us, please.
Yeah, my question basically was just how on earth did economies mainly based on free movement of services, because modern economies are based on it, in particular the UK, how do they manage to make so little provision regarding services, and why in particular was it politically possible for the UK government to leave its immense financial services industry out of the equation when reaching a deal? How did that happen?
Okay, I mean, I think in relation to both of those great questions, we're probably just asking for volunteers from the panel. So who would like to go? Who would like to go first? Catherine, I think. Go ahead, Catherine.
It seems to me that the UK made a fundamental mistake in its negotiating strategy. The EU had a considerable interest in free movement of goods or having goods clauses, because the EU has excess provision in respect of goods compared to the UK. Putting it the other way, the EU has a trade surplus with the UK in respect of goods, whereas the UK has a trade surplus in respect of services in respect of the EU. And of course, it was in the EU's interest to try and repatriate as much of these services as it possibly could onto its own shores. And I think there's a fundamental problem that Brexiteers only ever really understood the trade in terms of goods, and therefore didn't really get the services dimension. It's interesting that even the Prime Minister, in his less than transparent speech on Christmas Eve, the speech where he maintained that there were no non-tariff barriers introduced by this trade deal, did admit we didn't quite get what we wanted in respect of services. And so it's quite clear that there was no political appetite in respect of services. And I was very struck, the Musicians' Union were giving evidence to a select committee in Parliament a couple of weeks ago. And the Musicians' Union said they'd never heard of Mode 4. And instead of ringing up a lawyer to try and find out what Mode 4 might be, they decided to go to the Institute for Government, which is not a bad place to start, but they're not the expert on this. And the very fact that the Musicians' Union, who have now become very exposed and realised how exposed they are under the very poor provisions of the TCA on services, hadn't got a grip of quite what the implications of this trade deal might be. I don't know if Niamh wants to say something about.
Yeah, so I think Niamh, I can't see you in my screen, but
yeah, I'm here. Yeah, no worries. Yeah, just that's a great question, Gavin. Thanks very much. First of all, I completely agree with Catherine. I think if we think back over the last 3 or 4 years, it was always about quotas and tariffs. I mean, you know, and everybody else is screaming, saying, but that isn't relevant for services. You know, so I think it just didn't get traction on the debate. That this was a very, very different issue. Gavin, the financial services thing is absolutely, on the one level, utterly baffling, and on the other, kind of entirely predictable. I mean, in terms of the UK's position, I think part of it is sort of local politics. So one considers the financial crisis, one considers the somewhat lack of popularity of the city and things like bankers' bonuses. You know, it's not the most attractive sector. If you think about fishing getting such traction on the negotiations, you know, financial services was never going to do that. And then if we look back to the last year, when we really were in kind of the end game, we had the election, we have the Northern Wall, and the city is not a helpful part of that in terms of sort of devolving economic activity out of London. So I think there was a lot of kind of complex sort of local solutions, local issues. But there was other stuff going on as well, I think. You know, when the negotiation started, the city did some fabulously sophisticated and finessed work about how to construct Equivalence Mark II for the UK and the EU, without ever, I think, really engaging with the fact that the EU was never giving up a single rulebook. And the better way to engage with this was go from that, some base point, and kind of start out from that. Because I think the regulatory autonomy argument is very overplayed in the financial services space. you know, the UK has probably been most successful, I would suggest, in the financial services space. You know, they have pretty much written all of the major financial services measures over the last 20 years. I mean, the question for the EU is like, is there any point in continuing with a lot of this stuff? Because it's really designed to kind of cope with the city and the very complex trading and so on in the city. So it's sort of, to me, local political issues, hard for the city to get traction. And then this sort of huge noise around regulatory autonomy that just swept up the whole debate and just made it very, very difficult to get into any sort of a sensible negotiating space. But it is, I mean, you know, as Catherine was saying on services, it is a serious, serious issue that's going to have to be sorted out over the next couple of years.
Thank you, Niamh. I saw both Giorgio and Paola. I don't know who wishes to go first of the partnership. Giorgio, you seem to be talking, but you're muted.
May I start, maybe?
Yeah, go ahead, Paola, thanks.
Yeah. No, I think that, as I said before, this is a very old-style free trade agreement, completely focused on goods. And I think that the problem, one of the problem, of course, was that when the UK decided that the free movement of persons was so important and so important to prevent it was quite natural that services was not included, because services and free movement of persons are really connected. You cannot have a real free movement of services without the movement of persons, because if you consider, for example, the fourth mode indicated in the GATT, of course you have also problem I mean, it's very connected, free movement of person, I think, and services. And the second point is, my point is that if you consider the free movement of services in the EU context, I mean, it's a freedom not really completed. I mean that it's really difficult to say that there is a free movement of services within the EU. And in order to have this, I'm not talking of financial services, because of course it's something different, but in the normal services, also in the EU, it's very difficult to have free services, free movement of services. And you need, and the only way is to have the Court of Justice. I mean that you have the realization of the freedom if you have a court intervening in this situation where you have also a system, a dispute settlement system so light, it's quite difficult in the end to have a better regulation on service.
Okay, thanks, Paola. Giorgio, did you want to come in there?
Well, it was very more an observation thing, since most of you come from the UK. I mean, I am also a registered lawyer and I have acted internationally. I was struck by the fact that the powerful law firms in London did nothing for the freedom of provide legal service. We are back at the GATT level. And I saw a communique of Downing Street, our lawyers, well, they can provide legal opinion on UK law and international law in other European countries. That's ridiculous, I mean. And there is also the uncertainty, there is nothing on recognition of judgment on civil law cooperation. I mean, I think that, I don't know what you think, civil society in certain fields should have aligned against this confrontation. I mean, there are musicians in the UK, there are musicians on the continent, they both, and Ireland, and they both, and the public wants to enjoy them, and they should be free because it's part of the culture. I mean, this is ridiculous, and the same is legal service recognition of judgment, judicial civil cooperation. And I think the civil society has been blocked by this, as Paola said, just goods and cars and potatoes and tomatoes and wine. There is a long protocol on wine. So the wine, freedom of trade in wine has been more protected than any kind of more relevant things.
I think that's right. I would add that there are more references to fish in the TCA than there are to financial services. And financial services, what, 7% of the economy? Fish is what, 0.01%, something like that?
But you know, financial service, I still can understand. It's clear that the union tries to boycott London and bring these services to the continent with these equivalents. They did that with Switzerland. They withdrew the equivalent. It's highly politicized. But there are other services which are not in that situation. I mean, the lawyers, the musicians, I mean, you know, the textile, the fashion business, it's all over. I mean,
and just to add that the fashion industry is actually, in their open letters, they are really, you can feel how angry they are about the attention that the fishing industry is receiving. So now I think we have a fashion and fishing industry fight.
Okay, thanks everybody. So we have two more questions which I'll read out. The first one is from Arne Melchior. In some areas, e.g. partly for services, the EU is not fully harmonized, but this is often overcome via mutual recognition and passport arrangements. Without such arrangements, how often will the UK have to relate to each EU state rather than the EU? So have a think about that. And then I've got another one from Attracta Ivrin, who says, picking up from on a comment by Emilija, something that has bothered her about MFN is how that works in a mixed agreement where the EU does not have exclusive competency and ratification is also required at the member state level. So it would seem the agreement is legally with each member state also individually. So where is the base for MFN determined given member states give definite preferential treatment to other member states within the EU? So which panelists would like to volunteer for either or both of those? I think one is more or less directly addressed to Emilija. Would you like to have a go at that?
Not really sure how to answer that. It's a very complicated point and a very interesting point. The TCA, yes, it's a mixed agreement, like CETA is a mixed agreement. But as I said, we don't have yet.
No, it's not apparently.
Not a mixed agreement. It's an EU-only agreement.
They say it's an EU-only agreement, but it looks
That's
like
maybe why, since services are sometimes mixed, this could also explain why they didn't want to include too many services, because some would escape the exclusive competence of the union. I guess this could be a.
But it is certainly a EU only. It was deliberately designed that way to make it more simple to have it ratified on the EU side.
Yeah.
So you don't need.
The person who asked the question, Attracta, has sent a clarification. So she says she was asking this in the context of definite mixed agreements like the CETA, which is the subject of some controversy here in Ireland.
For the non-Irish, there is a legal challenge on the ratification of the CTA in Ireland, precisely because CTA is a mixed agreement. Yeah.
Okay, so there was, I know these are hard to pick up on when they're read out by me rather than the experts who formulated them.
You can call them as well, Iain, if you wish, and we can enable them to speak.
Yeah, so there was also the question from Arne about mutual recognition and passports, and perhaps this necessitating the UK to relate to individual EU states as well as the EU itself. Is there a response to that one? I have a couple of others stored up as well. I don't want to miss out a question I've asked already. That is, congratulations, that's a question that seems to have beaten the panel. Maybe they can think about it further while I ask some other ones.
Iain, I think Arne is trying to speak.
Arne, if you'd like to ask, if you'd like to clarify or elaborate, go ahead, please.
Well, I have not read all this impressive UK research on the distribution of competencies a couple of years ago, where I think it was 20 volumes or more. So you are really the experts. But of course, as at least here in Norway, we often think of this as a matter of the EU versus the UK and the relationship, whereas so we tend to underestimate the issue that the EU is not fully harmonized and rules are not fully harmonized. So yeah, so this aspect of what is mixed and not, you are the experts. But I think I heard this version that a challenge with Brexit is that that many that it will kind of bilateralize relations that have been solved by means of for example, mutual recognition, let's say professional competencies in professional services or in services delivered generally. So you have these mutual recognition arrangements that kind of overcome the heterogeneity of EU rules. So you do not anymore have this passporting or mutual recognition arrangements. You will have to bilateralize many relations. So that was my question. How important will this be?
Paola?
Yeah, I only look at the good provision, trade of goods, and because it's really complicated. But what I saw in the good provision, in trade of good provision, is that this fact that many of the decisions, it's just the beginning of a process. We have some general principle, but then we will have many discussions, and this discussion will be in these technical committees, and they have in some way a lawmaking power because they can make rules. And I think that this is maybe it's possible, but I'm not sure that it's possible also in the other sector, that this kind maybe there will be many negotiations also about professional and the recognition. It seems to me that this treaty, the idea behind this treaty is to continue and negotiate something that the UK already had, more alignment with the EU. The UK started with the same regulatory standard, and now with the TCA we start again from the beginning, and we set up a system, a complicated system to negotiate, and in the end to have the same result. So I think, I'm not sure, maybe Catherine can say something, but I think that this is the standard of the treaty, and maybe it's the same also for the person.
Okay, thanks, Paola. We now have loads of questions, unsurprisingly, as we're running out of time. I think Catherine wants to reply quickly to Arne's question, and then we'll try and get through some of the remaining questions concisely. Go ahead, Catherine.
So I would just want to say that in respect of mutual recognition, there is virtually nothing in the treaty on it, except there does seem to be a footnote which indicates that it could be done on a bilateral basis. But the problem is that our understanding is that the EU is leaning very hard on member states to stop them doing anything bilaterally, even where it probably is member state competence. But the trouble is, it's often very unclear precisely the scope of member state competence, because the EU is now touching upon so many areas. So you've already got the directive on mutual recognition of qualifications. So is mutual recognition really a domestic area, an area of domestic competence, or has actually the EU occupied the field? Now, of course, all of this are wonderful questions for lawyers to debate, but you can understand why there was an attempt, if they were determined to make this an EU only deal, and it looks like there was at the last minute, Paris was squared to agree to it being an EU only deal in order to avoid having to go through referenda in a number of countries. But nevertheless, it leaves a lot of things uncertain, mutual recognition being a good example.
Okay, thank you very much. So listen, we have, I think the next three people maybe should just speak out their questions, because a couple of them are just too complicated for a mere political scientist like me to even try to summarize. So we'll take them all in a row if that's okay, because that's just a little bit more efficient. So first, before having the answers, so Sir Ivan Rogers, if you'd like to unmute yourself and ask your question, please. Or maybe not. Perhaps you can come in at the end after the others ask their questions. Professor Dagmar Sheikh, if you want to ask your question, please. I think it might be easier for you to say it out than for me to summarize it.
Dagmar, you can speak.
I have a question on Niamh, really, on the financial services. And that's a long time ago that you spoke. So you said that it would be much better for both sides, the EU and the UK, if the financial services channels were open between the two parts. But then I recall that you also mentioned that the EU is a bit still in shock of the financial crisis. And how, if the EU is not in regulatory control, how can they prevent those risky financial instruments, which are more typical for the Anglosphere, for want of a better word, to come into the EU and to cause a similar disruption?
Thank you. Okay, and we'll add one more to the trio. We should be able to handle that. Iain Forrester, please. Actually, there's only one person in the trio at the moment. I think I'll read out Ian's one, because maybe he's left the room.
I think Iain can speak now.
He's here.
Oh, here. Oh, go ahead, please.
I was just answering what one of Giorgio and others have made easily understandable protests. Why on earth didn't someone think about this? Surely, surely someone must have failed in their duty. And sadly, we can see many particular instances now where the spin from government, from Downing Street, I suppose, towards the newspapers, gives precisely the reverse impression of what politically is going on. So recently we heard last week about garden centres. Garden centres, this is spring, COVID is over, the plants are sprouting, there's going to be green everywhere. And garden centres have thousands and thousands and thousands of costly plants, which normally would be shipped to the European Union, the 27, and they can't be. And this is presented by my favorite journal, the Daily Mail, as being a cruel assault upon British nursery operators. And it's precisely the opposite. It's a choice which was made by HMG, and which HMG is avoiding any political consequences for. Very, very sad.
Thank you. So I think we'll have Niamh respond quickly to Dagmar's question, and then whoever wishes from the panel to respond to Ian's question.
Yeah, thanks, Iain, and many thanks, Dagmar, for your question. I have two quick comments, I think, in response in terms of the balance of interest. So, I mean, what has the EU got to gain? I think a lot of this is the post-COVID recovery. I mean, the weight of private risk sharing that will have to be taken is really significant to lift the fiscal burden from tax across the EU. So capital markets in the EU have got to be able to support bonds and equity, and there just isn't the capacity in the EU right now to do that. So whereas there will be in the UK, so it's trying to keep that open. You make a really good point then about the EU wanting to retain control over certainly investor protection and financial stability in its sector, and that really is at the nub of this. I suppose one of the problems is financial markets live and die on trust, and that's kind of at the heart of what's going on here. So right now, the UK rule book is the EU rule book. It is a very, very high quality one. It's been largely shaped by the UK. The UK has no incentives to deregulate, none. I mean, in terms of presenting its position internationally, financial centres do compete on the quality of regulation. So there's very few incentives for the UK to kind of reduce its rules in that regard. And indeed, in terms of how equivalence works, it usually allows the EU to, for example, prohibit products from a third country if they cause difficulties in the EU. So that's usually kind of part of the process. It's just this huge lack of trust. You know, what if the UK does deregulate? And I think it goes back to your point. I think, Dagmar, there's a very, very long shadow from the financial crisis where we kind of saw what happens when you have a lack of trust between jurisdictions internationally. And it's sort of how you bridge that. My own tuppence for what it's worth is I think the faster this moves out of the political space and into the technocratic space, the better. So once it becomes a matter of negotiation between the European Central Bank, between the European supervisory authorities, between the Bank of England, between the Financial Conduct Authority, we are much more likely to get resolution here. But while it's up in the political space, it is a very sort of noisy area at the moment.
Anyone want to respond quickly to Iain? I have two more questions, so we might actually just fit everything in.
Iain, of course, is absolutely right. And part of the issue is that nobody saw the text of the treaty until Christmas Eve, and it wasn't actually published till Boxing Day, and it was rammed through Parliament on the 30th of December in 5 hours. And there were MPs who proudly announced they hadn't even looked at it, which is really quite shocking. And I think this was a deliberate choice on the part of the government because they knew that there was stuff in there that would cause serious concern to different sectors. And actually, it's only now beginning to be felt, and it won't be felt properly for at least a year until COVID starts to abate. And while we're hearing complaints from shellfish producers and nurseries and a range of musicians and fashion houses, the reality is the full implications of this are being significantly disguised by COVID because nothing compares to the 122,000 people who've died. And so it does sound a bit, unless you happen to be a shellfish fisherman, it does sound rather weak to be complaining about this against the backcloth of a massive pandemic. And this has covered up a huge amount, which is found, or more to the point, not found in the treaty. The one point I would like to very much agree with Niamh on, what we need at the moment is the whole thing to be extremely boring and to be dealt with by the technocratic committees, not by the Partnership Council. And the trouble is, as we're seeing at the moment, the appointment of David Frost and his intervention, shall we say, yesterday over the Northern Ireland Protocol shows that the politicians still want to keep poking at this very grouchy tiger rather than treating it with considerable care, which technocrats might do.
Thank you, Catherine. So our penultimate question, I think then, as it probably will be, is from Yulia Kasparovich. Is the fact that the governance architecture of the DCA is quite light, does that also justify the limited nature of free movement of services and freedom of establishment provisions in the TCA? And then finally, I would guess from Romualdo Canini, does withholding equivalence for UK financial entities risk to benefit mostly other third countries which already have it, instead of leading to a repatriation of business in the EU? So the last one, I think, is probably for Niamh. Who would like to take the first one from Yulia?
Emilija, do you want to do it? Do you want me to do it? Okay, so thank you for your question, Yulia. I'd actually say that the governance structure of the treaty is not light. I actually would say it's extremely onerous. There are about 32 committees that are set up under the TCA and under the withdrawal agreement, and that's going to require quite a lot of servicing. These committees are technocratic, and there are all sorts of issues that they raise about governance and, more to the point, democratic accountability. I hope that some of the really difficult issues can be ironed out through some of these committees, but some of them are structural. The shellfish issue is structural. The non-recognition of non-equivalence is a structural. It's not covered at all by the TCA, and frankly, all of the Mode 4 stuff is structural. It can't be dealt with through the relevant committees, and so you have a huge Christmas tree bedecked with committees, but really they are not going to make significant changes to the operation of the treaty.
Okay, thanks, Catherine. Niamh?
Many thanks for the question. It was a really good one. I suppose, you know, it is a bit of a long game on either side. I think the way I'd answer it is by saying that, you know, it's sort of follow the money, as it were. So if you look at markets since 2017, we are seeing the repatriation. It is happening, and it's interesting. It's been done. You want to see big speeches about this, or the city making a lot of noise about it. It's been happening fairly quietly, but it is absolutely happening. I think that I mean, markets are utterly unemotional, and if it's easier to move your subsidiary, that's exactly what they're going to do. And I think the other thing to kind of bear in mind here is, there is a sense in which the EU capital market is still a massive, massively untapped territory. So there are really strong incentives for UK firms to be in there, particularly when there's still this very strong political push to develop capital markets in Europe, and particularly post-COVID. So I think certainly over a 5, even 10-year period, there will be very strong incentives to move business to the EU.
Okay, thank you very much, Niamh. I am ready to thank everybody and finish on time. Federico, is there anything you want to say to close things off before I thank everybody?
I think you can maybe close, Iain, unless there is anyone from the panel. I could see Paola wanted to.
I want to add something, and about what Catherine just said, because in the trade of good chapter, that what I mean today, I understand today is quite an exception in the treaty. These committees has a very great power. I mean, think about the Northern Ireland and Ireland Committee. The regulation of the border control are just in the principle in the withdrawal treaty and in the protocol, and they have many powers to implement that. And one of the risks and one of the problems now is the implementation of these protocols and the non-ability of the committees to make this protocol works. And I think that at least for the trade in goods chapter, this committee has a very strong power, especially, for example, origin of goods. And I know they are very technical issues, but they can change really the relationship. Thank you.
Okay, thank you, Paola. Thank you to our really brilliant panel of Giorgio Sacerdoti, Paola Mariani, Niamh Moloney, Catherine Barnard, and Emilija Leinarte, and all the everybody else who put in a whole pile of great questions eventually. And thanks, of course, perhaps most obviously, to Federico and Catherine in the Brexit Institute and everybody working with them for organizing such a great event. I think Federico has a couple of house